Karl vs. Billy, Day 7. By ersatz_cats. Hello again. We've finally made it to our final leg of trial day coverage of the nearly finished legal battle between disgraced gaming hack job Billy Mitchell and absolute legend Karl Jobst. With the partial exception of Day 1, Day 7 isn't like anything that came before it. The tables turn. During the lunch intermission, Chat and I were still freaking out a bit about KB's blunder. Was there any way to get a correction on the record? Was that even allowed if KB's closing arguments were considered finished? Then I remembered that, in my wallet, I still had the business card Mr. Barber, Karl's solicitor, gave me the morning of Day 3, when he asked me to contact the person who wrote the note about Billy texting his son. Aside from Karl directly, this was the only way I had to contact someone in the defense party directly. And so I took a shot at sending a message his way. I never heard back from Mr. Barber, and honestly I was not really expecting to. But it was all I could do. Following lunch, the clerk called for all to rise for the judge's entrance. KB remained standing, clarifying the missing citation mentioned earlier. KB then said he had another thing to raise, saying he did not want to misstate the evidence. Your Honor asked me, in relation to aggravated damages, it was put to me the timing of when the video was taken down, put back up, and taken down again. Your Honor put to me that the video was taken down, then my client received text message from Keemstar and a concerns notice and contact with Apollo's brother, and then put the video back up. That's not right. I can give you the transcript reference. KB clarified that the original video went back up after Karl received the concerns notice, then cited the Day 4 transcript to show the contact with Apollo's brother was the same day the contested words came back down. KB added he wanted to get that corrected given the judge's interest, reiterating that the brother's contact was the catalyst for bringing the video back down. Judge muttered little in response. But cheers and high fives came through in our chat. It's super doubtful my outreach played any part in this. Again, Karl knows the timeline, and was likely on his own attorney's asses for such a basic blunder already. Either way, at least this was corrected on the record. At this point, KB finally took a seat, and BB began his presentation. Before I continue, note again that I'm just going to relay what BB claimed and argued, and that I won't be fact-checking each of his claims the way I would in a proper publication. In other words, I'm not asserting that BB's claims are true, just that he did make those claims. BB said he was proposing a similar course to KB, intending to discuss general matters, addressing KB's written submission, and going through his own written submission as well. KB then apologized for his earlier noted error, before referencing his own chronology of events. KB referred to a tweet by Karl to the effect that he removed the contested words, not because they were wrong, but because he would rather Billy sue him over something else, noting that this tweet was made on June 5. I was not sure if this was a correction to what BB had written, or otherwise the relevance. BB noted also that the replies to Karl's video are in fact entered into evidence as an Excel spreadsheet, including a column denoting timestamps. In the moment, I was curious how those were entered, given I didn't recall any testimony authenticating them, before BB clarified they were entered by agreement. I take this to mean, Karl's side agreed out of court that these represented the replies to his video. BB then sought to address the absence of testimony from Evelyn Mitchell, asking Judge if he could refer to Billy the father as Mr. Mitchell and Billy Jr. as William. BB noted that it was never asked of either Mr. Mitchell or William as to whether Evelyn could have appeared in the trial, or whether she would have been available, arguing that any negative inference would thus be unavailable. Judge countered that it's not necessarily a matter for Karl's side to put to BB's witnesses, but rather for Billy's side to explain her absence. Judge continued, if a person is a witness who one might expect would be called for their side, then the failure to call them, when unexplained, could lead to a negative inference. Judge added this was why he raised the question, given she could have testified to numerous matters, including Billy's social media and financials. When Judge noted that a negative inference could thus arise, BB replied by emphasizing the word could. Judge then chuckled and remarked that, when he raised the question, KB jumped on the suggestion. BB asked to make the point that this didn't seem to be an issue with the defense prior to the judge raising it. Judge asked, are you saying I shouldn't make such an inference? BB paused a moment, before saying, well. Yes, ultimately. BB continued by asserting that what her testimony would have gone to was instead addressed by others, adding that his side was cautious not to duplicate witnesses on issues that aren't central to the matter. Judge replied that the issue of whether Billy was paid for his appearances or not is a central issue, noting that Billy testified his later appearances were never paid, adding that per his recollection it was Junior's testimony that she controlled the finances. BB replied that it was Billy's testimony that he was paid for some of those later appearances, and that they're not arguing otherwise. Judge laughed and remarked that he may have exaggerated when he used the word never, and that he should never exaggerate. BB continued that there was a particular event where Billy was asked if he was paid or not, adding that the issue may be limited to whether that one appearance was paid. At this point, BB brought the judge's attention to KB's submission, starting with a section dealing with credibility. BB began addressing KB's attempts to question Billy's credibility by noting that Billy's testimony stretched across 3 days. In particular, BB noted, Billy's cross-examination was extensive, lasting from late on day 1 to lunchtime on day 3. BB then claimed Billy was generally respectful and gave compelling evidence. I promise, I will try not to insert my own commentary too much in between BB's remarks, but right away, as someone who personally witnessed almost all of this testimony unfold, would not characterize Billy's repeated emotional outbursts or glib retorts as respectful. BB claimed this was particularly true of the effect Karl's video had on him, adding that much of that testimony was consistent with the testimony of others. BB recalled that Junior testified that he'd heard his father vomiting, and that Triforce and Walter Day remembered Billy being angry over the video. BB noted Billy could generally recall facts without the assistance of documents, including dates of events and high scores going back to 1982, adding that this testimony was consistent with the documentary record of those scores. BB also asked Judge to recall that Billy could remember the wording of various tweets without assistance. BB then cited the portion of the transcript reflecting Billy's high score recollections. BB then characterized one of KB's written arguments against Billy's credibility as an unfair criticism. BB asserted there was evidence about the effect of Karl's video on Billy's appearances, adding that there was consistent evidence from Junior about the number of appearances before and after Karl's video. BB added there was no requirement to provide financial documents, since they're not arguing a case of financial losses. Thus, BB disputed a criticism from KB to that effect, adding that he, BB, himself was interrupted for making that mistake as well during questioning. BB argued that it was never put to Billy whether there were events he could not or did not attend, or whether his testimony about events prior to the video were not correct, asserting that most of the questioning was about Billy's appearances after Karl's video. After a moment, BB then remarked he was attempting to read his own handwriting from that morning, before having a quick sidebar with Solicitor Francis. BB added that, during questioning about post-publication events, Billy listed from memory 6 or 7 events at which he appeared following Karl's video, noting that the fact of these appearances was volunteered freely. BB remarked that, earlier this day, KB claimed there was an inconsistency in Billy's testimony due to an invoice. BB then directed Judge to a portion of the testimony transcript, where Billy testified he was paid at that event 1 year and was not paid the second year. BB thus claimed that all Billy did was confuse 2021 with 2022. BB then referred to the Twin Galaxies proceedings in California, asking to make a couple points about the impact of that on Billy. Regarding the discrepancy in claims of damages, BB argued that there are differences in the defamation laws between the different jurisdictions, especially in the United States where defamation claims have to deal with Article 1 free speech issues. I'd assume this was a reference to what we in the US call the First Amendment and not actual Article 1, which outlines the structure of Congress. BB noted that, much was made of Billy's deposition testimony in the California proceedings, before asking the judge to refer to the transcript of Billy's testimony. BB cited Billy's testimony to the effect that he did not understand the question in the TG matter as referring to the Karl Jobst video about Apollo legend at the center of these proceedings. BB then recalled his question, asking Billy if his answer would have been the same had he understood the question as referring to that video, to which Billy answered, no, not at all. Judge then asked what this is relating to which BB replied this was about Billy's deposition answers in the TG proceeding. Judge immediately recalled Billy said similar words there to what he said here about the TG comments, that their effect was minimal in comparison. BB spun it as follows, as I understood it, he believed he was being asked about the impact it had on the cheating allegations. So as I understood his evidence, the Twin Galaxies proceeding was about defamation through cheating allegations. And he thought, when he was being asked about the impact of other videos and publications, he understood that to refer to their impact on the cheating allegations. Because Mr. Jobst also published videos about Mr. Mitchell allegedly cheating. And so I understood his evidence to be that when he was asked about Jobst's videos, he thought he was being asked about the ones where he claimed Mr. Mitchell cheated. Judge asked whether this illustration referred to this case or the Twin Galaxies case. BB noted it was in reference to the TG deposition, adding that everything he summarized was Billy's answer to why he gave the answer he did during the TG deposition. Judge remarked that maybe Mr. Mitchell's explanation here which I heard an emphasis on the word here, before asking if that full deposition includes testimony from Billy about Karl's other videos. BB replied the whole deposition is not in evidence. Judge clarified his issue, illustrating that Billy gave an explanation here, for what he thought he was responding to there, but all the other questions leading up to that point which might have led him to believe that framing at that time, those questions have not been entered into evidence in this case. Judge then also noted that, since Billy was not cross-examined on this point and shown those earlier questions, there is no evidence contradicting Billy's narrative. More on this later. BB pointed Judge toward Billy's testimony regarding his texts with Carlos, and Billy's assertion that he did not believe Apollo was dead when he sent those messages, and would not have sent the messages if he believed Apollo was dead. BB noted Billy's testimony that he regrets sending those messages, and Billy's and Junior's testimony to their reaction when they later learned of Apollo's suicide, including their attempts to reach out to Apollo. BB noted a claim from KB that Triforce's testimony was unhelpful to Billy's case, to which BB disagreed. BB cited, from his own submission, Triforce's testimony that Billy was held in high esteem in the community, and that Triforce referred to him as the Michael Jordan of video gaming. I was waiting for BB to make a subsequent assertion about Billy's reputation after Karl's video, given that was the whole point of that subject. Instead, BB moved on. BB referred to KB's characterization of McNutt's testimony, that Billy was a great guest. However, as BB pointed out, McNutt testified he'd never seen Karl's video, so he can't know the impact it had. Therefore, as BB suggested, any argument regarding the impact on Billy's reputation based on McNutt's testimony can't go very far. BB continued to argue, as a point of law, that they don't need to show that every person who saw Karl's video thought less of Billy, adding that if the court finds the accused imputations arise and are defamatory, that there is a presumption of damage. BB also noted Billy's witnesses were lifelong friends who would not have believed the allegations. BB then addressed KB's submissions about Karl's credibility, noting KB's position that Karl made reasonable concessions and was never untruthful. BB then referred Judge to his cross-examination of Karl regarding the correction video, and attempts by Billy either through his attorney or through Keemstar or through his own video to correct Karl's claims. BB then pointed out Karl's refusal to accept that Billy's concerns notice was him reaching out to correct information, citing that as just one example that contradicts KB's claims of Karl's credibility. BB added that he dealt with credibility of Karl's witnesses in some detail in his written submission, pointing Judge to his conclusionary paragraph. BB proposed a comparison of both sides' witnesses, positing that Billy's side called witnesses who actually knew Billy, who actually saw how he interacted with people, and who could speak more knowledgeably to Billy's reputation. Comparatively, BB said many of Karl's witnesses had axes to grind with Billy, or in some cases faced lawsuits from Billy themselves. BB noted Charlie White makes a living out of publishing videos, some of which attack Billy. BB suggested this led to the disparity in the types of testimony given about Billy's reputation. BB also argued that most defense witnesses understood Billy's reputation from what they'd seen online, but didn't identify specific sources for that information, which BB argued opened the door to suspicion and rumor. Therefore, even if Karl's witnesses did have the impression of Billy's reputation they claimed to, it could still have just been based on rumor. Regarding the effect of Karl's video on the number of Billy's appearances, BB recalled testimony that Billy had 20 to 25 paid appearances per year prior to the video, compared to around 15 appearances in the 3 years afterward. BB added that those post-video appearances were a mixture of paid and unpaid, and that this equates to about 5 appearances per year, arguing that even based on this Karl's video has had a significant impact on Billy's reputation. BB then addressed the issue of publication, noting that the video was published in requisite legal terms, including in their jurisdiction, pointing to Grunberger's testimony that he downloaded and watched the video while in nearby Gold Coast. Judge then interjected to ask about the word downloaded, remarking his impression that when watching a YouTube video, one does not download it onto your computer, and that the video itself stays on whatever server it was watched from. BB noted he uses that language because that's the language used by the High Court in a previous case. Judge agreed that is indeed the language they used, but pondered whether or not that's accurate, noting that if videos like these were not downloaded, then by their definition they could not be publications, noting that would not seem right. BB opined, I think the intent is that it's downloaded to the extent that, digitally, the code comes through the interweb, onto your computer, from where you can observe it. And yes, I swear to you, BB said the word interweb LMAO. Our chat had a good laugh with that. BB posited that's what makes it consistent with buying a newspaper, or turning on a television, that you are receiving the media and then watching or reading it. BB returned to the topic of Grunberger watching the video while in Queensland, and Billy Jr.'s testimony of watching the video, as well as Karl's witnesses that they had watched the video. Judge then noted, apparently based on the written pleadings, that BB was relying on 3 different venues of publication, in Queensland, in Australia, and throughout the world, before asking BB if he's relying on publication outside of Australia. BB indicated he is doing so, as it relates to assessing damages and the extent of the publication beyond just this jurisdiction. Judge asked for the legal authority for that proposition, to which BB indicated it should be in one of his other cited cases, adding that one can infer publication in relevant circumstances. It's AME. Photo source. At this point, BB invoked a 2022 Australian case BB identified as Barilaro v Google, although it seems the actual case name is Barilaro v Shanks Markovina and Google. The impression I got from our live chat is that those of you reading this are either thinking, literally who? As I was, or are going, no fucking way. Out of nowhere, I got a DM from my faux friend from day 5, who was following our chat, and who explained to me the relevance of this case. In short, a YouTuber named Friendly Jordies published a series of videos criticizing politician John Barilaro, the Deputy Premier of New South Wales, accusing him of corruption. This was a huge ongoing thing, where at one point Friendly Jordies showed up to a live event taunting Barilaro while wearing a Luigi costume, yes, a Luigi costume. All of this led to a defamation lawsuit from Barilaro, as well as allegations Barilaro lied in a police report and weaponized government counterterrorism forces to harass Friendly Jordies' producer. Oh, and Barilaro also sued Google for refusing to take down Friendly Jordies' videos. This is apparently a highly notorious case in Australia, and despite it never having come up on my personal radar half a world away, it honestly does sound fascinating. However, I will leave it to you, my intellectually curious readers, to explore the matter further as you wish. BB explained the citation, noting that the Barilaro case was also over a video on YouTube. BB added that this case discussed the number of views on Friendly Jordies' video, and the fact Google failed to produce certain analytics of the video as required. BB noted that, while Google was not present in this case, there was discussion of the absence of analytics information. BB then pointed to portions of the testimony transcript dealing with analytics, and specifically viewer retention data, arguing that Karl's side failed to provide such viewer retention analytics in disclosure. BB continued recounting Karl's testimony, where Karl was asked about these analytics, and about his decision to place his correction at the end of another video. Karl had answered that it was because of the way retention works on YouTube, noting that more people watch longer videos, which boosts how much YouTube will promote the video. Karl also cited watch time and click-through rate as important metrics, but admitted he had not disclosed that information. BB then asked to move on to matters of imputations and defamation, pointing to where KB's written submission broke down the semantics of the contested words from Karl's video. While I obviously don't have the written submission, BB suggested that KB at times flipped between a summary view of Karl's words as one would hear them, and a careful analytical view breaking down each word by itself. BB then cited a case called Favell v Queensland Newspapers, involving a newspaper report on an arson which was alleged to imply fault for the arson. From that case, BB cited a quote from a judge in a previous case, which I was able to track down. It is the broad impression conveyed by the libel that has to be considered and not the meaning of each word under analysis. BB posited that the problem with KB's approach of dissecting Karl's words is that it delves into this sort of analysis which a higher court has already forbidden. At this point, Judge remarked on the difference between YouTube and a television program, which is broadcast at a particular time. Judge remarked that, absent modern capabilities to rewatch such shows, you'd typically see a television show once and thus gain a single impression upon which an imputation could be drawn. Judge then pondered what approach he should take with a YouTube video and what kind of imputation could be drawn, whether it would be the impression of someone who watches it once, or someone who watches it multiple times. BB proposed it ultimately doesn't matter, that it comes down to how one interprets it when one watches it, not when one hypothetically pauses it to ask whether a given word is being used as a conjunction or disjunction or whether the first part of this sentence refers exclusively to the first part of the other sentence. Judge remarked that, with a newspaper article, one may read it more than once, before wondering if the standard should be the impression one would get upon first reading and not when one analyzes in greater depth. BB acknowledged there are cases where one could hear a statement, go, wait, what was that, and backtrack to hear it again, but suggested that even in those cases a viewer would not pull a sentence apart in the sort of analytical detail KB is attempting. BB brought up the question of whether the alleged imputation arises from Karl's video, acknowledging that it's a question exclusively up to his honor and not to the YouTube commenters, although BB also suggested the task is made easier because of those comments. BB said he would rely on his written arguments to that end, before addressing KB's written arguments over whether the alleged imputation is defamatory. BB cited some other case law named Bros, which I believe to be Bros v Beluskas. From 2020. Given the later context, I gather it was a case initially cited in KB's written arguments, which BB is now attempting to address. BB suggested that, contrary to KB's written arguments, the Bros case establishes the matter should still be considered from the perspective of the reasonable, ordinary viewer. The judge in that case noted the media must be acknowledged in its context, before examining a post on Facebook in the social media context. From that case judgment, BB pointed judge to several of these considerations, including again that context is relevant when considering whether a publication conveys a defamatory meaning. BB continued that the plaintiff in that case ultimately succeeded, arguing thusly that just because a post was made on Facebook does not mean it can't be defamatory. BB then argued this cited case was from 4 years ago, and that things have moved on since then. BB cited another more recent case alleging Facebook of disseminating a defamatory publication, dealing with the obligations of social media websites. BB then noted that, although the judge in Bros ruled that social media comments are an unregulated, Wild West, BB argues courts have since moved on from that position, and that sites like Facebook and YouTube are now regulating material more closely. Thus, BB argued, these later judgments lessen the impact of the Bros ruling. Judge dryly remarked, "That's a difficult submission to accept, Mr. Summers, given that when I look at the videos in evidence in this proceeding, and the comments that were made in this proceeding, there seems to be no regulation of either." BB acknowledged Judge's point, but submitted that should not prohibit his client's success. Judge agreed it wouldn't necessarily do so, just that it wouldn't appear social media has moved on in the way BB is describing. BB countered that he's not saying there aren't untoward things happening online, and was not trying to compare it to traditional media with industry regulations, but is saying that things are changing in the social media sphere. BB then pointed back to the Barilaro case again, explaining that Google was sued by Barilaro over certain videos, while asserting those videos bear some similarity to Karl's video in this case. BB directed to judge to a certain portion of the Barilaro decision to argue that courts are now looking at guidelines in these unregulated matters, suggesting again that things are changing contrary to the Bros ruling. BB then discussed what he considered the similarities between FriendlyJordy's, Bros video and Karl's. Of these alleged similarities, BB listed only parodies and Mario Brothers characters. I couldn't say if a longer list was reflected in BB's written arguments. BB argued that the defense that videos like these should be taken with a grain of salt because they're for entertainment and not serious shouldn't hold up in light of the Barilaro decision. BB then reiterated that, even in the context of the YouTube community, these videos can carry a great sting to a person's well-being and reputation. He does give a damn about his bad reputation. BB asked to move on to the topic of reputation, asking if Judge had any further questions about the prior matter. Judge indicated he was doing the same as with KB, writing down his own questions to save them for the end. BB pointed to point in KB's submission arguing that Billy's reputation was not further harmed by Karl's video, with BB positing that submission is not consistent with the evidence. BB then suggested there's been no pleaded case against them that, absent the allegations of Billy having a pre-existing bad reputation, that there was no damage to Billy's reputation either way. BB expressed his concern that KB's submission was arguing in that direction, noting such an argument without a pleading should not be considered. BB reiterated that the only reason Karl's side argues that the video didn't affect Billy is because they allege Billy already had a bad reputation. BB then said his own written submission covers the harm they allege Billy did suffer to his reputation, citing particularly Billy's event appearances. BB then pointed to various citations in his written submission, reminding the judge that much of the trial testimony was focused on this issue. BB then noted this narrative is consistent with testimony from Billy Jr., adding that contrary to KB's submission, Jr.'s testimony was honest, compelling, and direct. BB then noted that much was made of Billy's reputation from the movie King of Kong. BB made a point to say, the only time King of Kong was specifically relied upon was to cast Billy as a person who ostracizes he considers a threat to his high score records. Thus, BB argued, King of Kong should be seen as having only a limited effect on Billy's bad reputation. BB also noted that, in his belief, none of the defense witnesses used the word ostracize, arguing that that characterization of Billy's reputation is also not substantiated. Judge then asked, aside from the word ostracize, whether BB is arguing that no witnesses said words to the effect of, if you challenge his records, either by saying they're false or by beating them, he'll have nothing to do with you. BB agreed, admitting that Billy was called plenty of other things in testimony instead, such as a narcissist and a joke, but that he was not accused of ostracizing people or acting in the way Judge described. BB also argued there was testimony from witnesses acknowledging that Billy was playing a character in King of Kong, comparable to a wrestling heel. BB noted the terminology may not be appreciated in Australia, but that one of the witnesses used that term, adding that either Mr. Burt or Mr. McNutt recalled Billy playing such a character at conventions. Judge recalled the testimony that Billy would either smile or scowl for photos depending on whether he was asked to be the good guy or the bad guy. BB argued that people understood this to be part of the Billy Mitchell character. BB then posited that there's uncontested evidence that King of Kong was ultimately good for Billy, citing Billy's own testimony that all his benefits have flowed from that movie. BB recalled a moment from McNutt's testimony where KB suggested that any publicity is good publicity, to which McNutt agreed. Judge asked if he should infer the movie didn't lead to a poor reputation, to which BB agreed. BB then argued that, per Billy's witnesses, the Twin Galaxies allegations did not significantly alter Billy's reputation or popularity. BB noted that he stresses the word significantly, because Billy accepted it did have some impact, but that according to Billy it was only for a short time. Before continuing, BB clarified that when he speaks of the Twin Galaxies dispute, he's referring both to the score dispute of 2018 and the later litigation commenced in 2020. BB noted Billy's testimony that he attended up to 25 events per year during that time, and that he couldn't even accept all his invitations. BB said there was also testimony that many people understood the TG dispute as a dispute between two figures in the arcade gaming world, and that it was TG's findings on one side and Billy's claims on the other. BB suggested there's testimony from Burt, McNutt, and Triforce to that effect, as well as from Mr. Young for the defense. Judge immediately remarked that Mr. Young was the person who did the initial investigation and uploaded the evidence, launching the allegations of cheating. BB then called back to the Donkey Kong forum poll, citing Jeremy's acknowledgement that Billy had a mixed reputation in the community, that those who were against Billy's side thought he cheated and those who were on Billy's side thought he was good, adding that this characterization was consistent with the poll. Judge then asked what the court is supposed to do with reputation, noting that in almost all cases, there are people who support the plaintiff, and those who do not. Unless you can show that people who once supported a plaintiff went against him because of the defamatory comment, how do you show that a reputation has been damaged? BB then posited that what the court must find, and will not find, is that it was a settled reputation by the community. BB continued, there will always be someone in the world who doesn't like you. Judge countered that if half the world thinks you're a bad person, and half thinks you're wonderful, and then someone makes a defamatory comment about you, and half the world thinks you're bad and half thinks you're wonderful still, would that not indicate your reputation was not damaged by the defamatory comments? BB replied that it's a bit different here, where you can't find that it was a settled bad reputation held by the majority of the community. Judge remarked that this argument would counter the defense position that Billy had a settled bad reputation, and thus the video did not harm Billy further. BB agreed, adding that Judge should not find that because it was a mixed reputation, not a settled one held by the majority of the community. BB then returned to Judge's analogy, suggesting this wasn't a case where half the community liked Billy both before and after, arguing the video still had an effect. BB argued that the testimony showed that, if it was a split reputation, Karl's video moved more people from one camp to the other. BB then suggested, when considering Billy's reputation immediately prior to Karl's video, Judge should consider the testimony about Billy's reinstatement by Guinness World Records in 2020. BB also remarked this had a lasting impact on the TG dispute, noting Billy's testimony that the TG dispute hurt him for a short time, as some people stopped communicating and some events cancelled him. BB also recalled Billy's testimony that he began playing on Twitch and at events to counter the cheating allegations, before suggesting this tied into Billy's testimony about the effect of Karl's video. BB recalled Billy's characterization that he knew how to defend himself against TG's cheating allegations, but felt frustration over Karl's video because there was little he could do to defend himself from the imputation that he'd driven Apollo to suicide, with BB adding that frustration was a big part of the impact Karl's video had on Billy. BB then circled back to his point about Guinness, recalling Guinness' reinstatement announcement and the attention it received. BB thus argued, the court should assess Billy's reputation immediately before Karl's video, adding that any effects of the TG dispute were corrected by 2020 with Guinness reinstatement and related media. BB then began to suggest none of the witnesses were asked about that part of something, before retracting the claim mid-sentence. At this point, I saw KB dramatically swiveling his head around, as if to performatively give puzzled looks to his colleagues. BB continued the discussion of reputation by citing 3 alleged bad reputations. First, BB acknowledged Billy was accused of cheating to gain recognition, adding that most of the defense witnesses did not identify sources for their impression of Billy's bad reputation. BB then addressed Billy's second bad reputation as someone who uses litigation to coerce others into recognizing him as a world record holder, noting that there were only 2 prosecuted proceedings with any connection to cheating. BB added, now, they weren't proceedings to coerce others into recognizing him. They were 2 defamation proceedings. BB cited one of these as the lawsuit against Apollo Legend, which was resolved when Apollo contacted Billy, with BB recalling Junior's testimony about Apollo reaching out through an intermediary and resolving the matter over Discord. BB suggested, it's certainly not evidence of coercing others into recognizing him. BB cited the other such case as the Twin Galaxies proceedings, adding that the David Race lawsuit was about telephone calls and that 2 other cases were not served. BB said this speaks to the point of bad reputation, and relying on rumors and gossip, in that some defense witnesses spoke of those other cases as if they were prosecuted proceedings, referring to 5 proceedings and such. BB suggested these witnesses obviously heard about these from someone else talking about it because some of those were never served. Judge countered that, while the cases may not have been served, they could still have become public knowledge, noting that Jobst's video discusses some of them, adding that even if they're not served, people could still view them as litigious processes. BB argued this would still not reach to establish Billy's reputation as one who coerces others into recognizing his world records. Judge remarked that it could be seen as coercing others into not making further statements that he's cheated, which is part of the relevant proposition. Judge added, perhaps a bit sarcastically, that defamation cases against people who alleged him of cheating could lead to him having a reputation as a litigious person who sues people who call him a cheat. Judge further remarked that these cases could also lead to Billy attempting to coerce people into retracting their comments and acknowledging him as having not cheated. Judge added that this is what Guinness World Records ultimately did, and that even though proceedings were not commenced in that case, they were threatened, which is a pre-litigious process which in that case led to exactly the circumstance described. Recall, this is all still discussing Billy's reputation as someone who uses litigation to coerce others into recognizing his scores. Judge then concluded, he's unsure it's right to say the evidence doesn't show some basis for some people to consider that to be Billy's reputation. BB acknowledged those proceedings were entered into evidence by agreement, but added that, when one knows the true fact of the proceedings, based on fact and not rumor and suspicion, that wouldn't give rise, when there's only those 2 proceedings, to a reputation of the effect alleged. BB continued to argue, even if a reputation was based on those 2 proceedings, it shouldn't lead to a bad reputation, adding, people are perfectly entitled to avail themselves of the court process. We'd have nothing to do otherwise. Judge continued BB's joke, saying, it keeps many other people employed, to which BB mused, God bless them. BB continued to ask, rhetorically, how does that create a bad reputation, when one knows the actual facts? BB then circled back to settled reputation as this third point. BB cited a ruling he called Peros, which I'm guessing relates to an Australian defamation case brought by John Peros against a true crime podcast. BB did advise caution when referencing Peros, noting the ruling was under what he called the new regime of serious harm, which reversed some earlier precedent regarding causation. BB suggested he didn't need to elaborate any further, to which Judge agreed. Yeah, obviously, fucking everyone knows about the new Peros regime of Australian serious harm causation law. What, have you been living under a rock? BB cited a specific element of the case regarding settled reputations based on reports and rumors, where the judge in that case observed the need for a person's settled reputation to be considered. BB then pointed back to his earlier arguments to this point, about the competing testimony in this case and the nature of the witnesses who were called, and how this affects an assessment of Billy's settled reputation. BB transitioned, I'd like to turn to the issue that was raised about my plaintiff's contribution to his alleged situation by way of his own video. First, BB argued that most of the impact of Karl's video had been done by the time Billy released his on the 4th of June. BB pointed to one of the available analytics documents, showing that between the initial release of Karl's video and June 4th, there were over 500,000 unique views, while specifying that these were unique views, and not total views, adding that a large majority of the total views of the video occurred during that time. Second, as BB said, much was made of the fact that my client put the offending words in his own video, and he did, but one must look at his video as a whole. BB notes that, both before and after Billy inserted the words, Billy strenuously denied everything Jobst said, and thus no reasonable viewer watching that video could miss Billy's emphatic denials. Thus, as BB argued, any argument that Billy's reputation was damaged because people watched his video has some difficulties, adding that no reasonable person could conclude that Billy's reputation was damaged when the video is watched as a whole. BB reiterates his recollection that Billy brackets his denials both before and after the segment pulled from Karl's video. BB then turns back to KB's written submission, where it was said Billy's witnesses characterized the allegations against Billy using the word murderer. However, BB argued that the testimony from Billy's witnesses regarding Jobst's claims did not rise to the level of a murderer. BB then clarified, none of these witnesses spoke of the allegation as involving intent. BB then pointed to a reference by KB to comments to Charlie's video, saying again that those comments go to the Grapevine effect, which BB intends to discuss later. BB then reminded the judge those replies to Charlie's video were almost 3 years after Karl's video, and that Charlie's video was relatively unrelated in that it discussed the cheating allegations and was not about the events between Billy and Apollo. BB then addressed the issue of sectoring, referring back to Peros and another case called McBride, while walking through various citations in his written submission. BB characterized the sector of Karl's claim as a propensity to harm or cause harm to another person's health or well-being, contrasting it with KB's characterization of the alleged imputation as a propensity to do harm to protect his reputation as a video gamer. BB noted the similarities in these characterizations, in that they both involve a propensity to do harm to others. However, BB added, the plaintiff side frames it more broadly, whereas the defense frames it as an attempt by Billy to protect his reputation as a video gamer, which BB argues is too narrow. This bit may be confusing, but basically it seems KB is arguing that Billy's side has to prove Karl's allegations involved Billy harming others to achieve certain goals. Whereas BB is arguing that, no, they just have to show Karl painted Billy as someone who harms others regardless of objective. Judge responded that it all still arises from the context of Billy being a video gamer, and wishing to protect his reputation as a world record holder against allegations he got those records by cheating, adding that this all relates back to Apollo's prior allegations that Billy cheated. BB noted that was the genesis of the conflict between Billy and Apollo, to which Judge remarked this means the issue between Billy and Apollo was indeed about Billy's reputation as an arcade gamer. Thus, Judge continued, that was the subject of this video by Karl, that Billy was an arcade gamer who Karl alleged was cheating. Judge continued to say, Billy sued Apollo over the allegation, and so the subsequent allegation from Karl was that Apollo was required to pay Billy a lot of money, which caused him problems, which led ultimately to Apollo's suicide. Thus, Judge posited, that's all in the sector of being an arcade gamer, and protecting that reputation. BB replied that it's all within the sector of video gaming, to which Judge remarked that's where Billy's reputation is. BB posited they take a different analysis, and start by looking at the nature of the imputations. Some of BB's argument was confusing, but it seemed BB's written submission was citing authority to suggest the court must look at the effect of the imputation and what sector of a person's reputation is affected by that imputation. BB then cited a 2001 defamation case called O'Hagan v. Nationwide News, which BB suggested relates to Judge's proposition of a reputation limited to video gaming. BB verbally summarized the case, where O'Hagan, a police officer, sued over an imputation that he paid to have someone killed. The defense argued contextual truth, in that O'Hagan already had a reputation from having pled guilty to misconduct charges as a police officer. BB noted the ruling in that case may appear at first blush to go against what BB is arguing, given the court ruled against O'Hagan. However, BB argues, what's important was the reason the court found it important that O'Hagan had the reputation of a police officer, and that the matter must be considered in a more broader sense. Per BB, that court found the sting of the imputation of paying to have someone killed was greater, because that person was a police officer. Thus, BB argued, the difference in this case is that Billy's profession as a video gamer is not to the essence of what they're suing on. Rather, they're simply suing on the broader imputation that Billy essentially caused someone to be in a position where they had to pay so much money that it was a reason for them taking their own life. Note that KB's oral arguments on this point were very hard to follow at times, but I believe this faithfully represents what he was getting at. Around this time, I noticed the other displayed viewer panels in the stream start to fluctuate. I checked the participants list and it seemed a total of 6 of us were watching the live hearing, not counting the court feed itself as the 7th participant. I began to suspect that every one of those viewers not named William Mitchell was in our ongoing chat. And who knows, maybe he was there, too. Judge appended BB's characterization of the imputation, being that Apollo allegedly had to pay Billy so much money, for having called him a cheat as a video gamer. Thus, Judge said, it's still directly within that sector of Billy's life, which is obviously the principal sector of his life. Judge added, he's being called a cheat, which must be one of the worst things to call a gamer, perhaps. BB remarked that pushing someone to suicide might be worse. BB then argued, if one looks at the imputations as they were framed in the pleading, the essence of the imputation is that, because Apollo was required to pay so much money, that was a factor in taking his life. BB argued, it's not, to use the O'Hagan analysis, because Mr. Mitchell is a gamer, and he settled a gaming proceeding, causing Apollo to pay so much money, while admitting that he was using what he called children's language by using the term gamer instead of video game player. Yes, Judge did say gamer first, lol. BB suggested, it wouldn't matter if Billy was a doctor, in a medical negligence case, arguing that the sting of the imputation is no greater for the fact Billy is a video game player, saying this is an important distinction to draw from the O'Hagan outcome. BB reiterated that O'Hagan appears at first blush to rule the other way, before having a quick sidebar with Francis to clarify some citations. BB then refers back to McBride and another case called Fitzgerald, which weighed whether or not the sting of the imputation is greater because of the profession. BB expressed recognition for Judge's thought process, before arguing again that, in this case, that should be the distinguishing factor. For what it's worth, during the subsequent silence, I could see KB in frame, giving a slight expression I interpreted as, WTF is this guy talking about? BB noted that, in his submission, they accept that the second alleged bad reputation, that Billy uses litigation, would be within this sector of Billy being a video game player. BB continued by rhetorically asking, how do you get to the point that, because someone thinks you're a cheater as a video game player, that has a greater sting than that you caused someone to take their own life? BB then noted at the later point could be an aspect in anyone's life, which is why BB argues the third and first alleged bad reputations are of a separate sector. Moving into remarks on contextual truth sectoring, BB posits that the first and second alternative imputations are along those cheating lines, being banned and such, and thus BB declares he would make the same point. At first, reviewing all of this days after the hearing, I was confused by this reference out of the blue to first and second alternative imputations, until I realized it relates to an older filing, which I showcased back in Day 0. And yes, for the folks who wondered why this Day 7 write-up took so long to complete, stuff like this was why, lol. BB then referred to the third alternative imputation, relating to Billy's wacky phone plot to fabricate evidence, arguing that this also does not fall in the same sector or have a greater sting than the other imputations. Judge interjected, that's clearly in the same sector, isn't it? BB reiterated the imputation as being that Billy planned to use a video to fraudulently use as evidence to justify a record. Judge noted again, this was to justify Billy's video gaming records, and thus was within the sector of his occupation as a gamer. BB countered, if that's the sector. If we look at it our way, then the sector is within the imputation that he acted as a factor in someone taking their own life. After some quick back and forth with the judge, BB continued, when you look at the imputation, which is that he was a contributing factor in Mr. Smith taking his own life, one's honesty or ability to act honestly, we say, is within a different sector of his reputation. So, if I may paraphrase, the argument Billy's barrister seems to be reduced to making is, in my words, just because my client may be a habitual liar doesn't mean he would wish anyone harm. Which I guess is accurate enough, but it's quite an argument to hear being made. After another quick clarifying question, Judge expressed that he did understand BB's argument about the phone plot and the Apollo imputation as involving different sectors, clarifying that he thought BB was trying to make a different argument about contextual truth. At this point, I couldn't tell you what that argument would have been. BB clarified he's not comparing each of these alternative imputations to each other, but rather comparing each to the sector of the main alleged imputation. For simplicity, from here on I'll refer to the matter at the heart of this lawsuit, that being the idea that Karl's words attributed responsibility on Billy for Apollo's suicide, as the main alleged imputation. BB then returned to his argument, reiterating that this third alternative imputation relates to the sector of Billy's honesty, which is separate from the sector of the main alleged imputation. BB posited this was also the same of the fourth alternative, the one that says Billy expressed joy upon hearing news of Apollo's death, which BB mused is now the defense's primary case. BB continued, we'd make a similar submission, that expressing joy at someone's death is a very different sector of how people perceive you compared to whether you caused that person to take their own life. At this point, I was feeling like Billy's case was not going well. BB doubled down on this position, reiterating that this sector of propensity do harm is a very different sector from callousness. Judge did not interrupt or reply to this. BB then moved on to the fifth alternative contextual truth, the use of litigation, which BB accepts would be within the same contextual sector as the main alleged imputation. BB continued discussing contextual truth, disputing whether one of KB's legal citations relates to this case as KB applied it. BB read from KB's written submission the argument, the defendant doesn't necessarily need to establish the substantial truth of all contextual implications in order to succeed. BB added that, while it's true the defense need only rely on one of these contextual implications in order to succeed, for any one that they do rely on, they must show that it's true. BB then remarked that a case ruling titled, Hutley, possibly Hutley v. Costco, discussed a plaintiff's imputation that was found not to be true, not a defendant's contextual truth imputation. I guess the latter must be the way KB cited the case in his written filing. BB cited Hutley as looking at a situation where the defense uses another truthful imputation to balance out the sting of competing contextual imputations, which BB posited is different from the argument put forth in writing by KB. Judge noted that the proposition in KB's sentence prior to the Hutley citation is from another case I couldn't identify, and not from Hutley. BB seemed to acknowledge this error and apologized for misunderstanding the linking of those passages. BB then added that Hutley still wouldn't help the defense in this case, since there's no truth defense issues with any of Billy's pleaded imputations. BB noted that KB focused on one of the contextual truths, while proposing he could focus his oral arguments on that one while leaving his written submission to deal with the others. Perhaps this was an acknowledgement that the day had been running long, and they didn't want to be there arguing this case into the evening? Judge chuckled and mused it was up to BB how to proceed, to which BB offered that he would briefly address the others as well for the sake of completeness. Note that BB did just cover each of these alternative imputations already, but that was in discussion of whether they were in the same sector of defamation Billy's complaining about. This time, BB's going to discuss whether these alternative imputations are established as true or not. BB pointed toward a passage dealing with the first alternative contextual truth regarding cheating, arguing that much of the material presented is not pleaded as matters going toward the support of that imputation. Judge then asked what that material is relevant to and why they're in evidence. BB noted a couple items as being pleaded toward the Grapevine effect, acknowledging that they are thus in evidence, but arguing they should not be able to be used to prove the cheating allegation because they were not pleaded against Billy's side as matters going to that imputation. Judge observed that if those comments are in evidence, they're in, and thus could be relied on. BB replied that he just wanted to note they weren't properly pleaded in that way. BB noted that, with these documents in this context, he would repeat his earlier arguments about the nature of competing evidence and reputation. BB continued to say that many of his other submissions could be repeated as well, regarding the cheating allegations, as they go to the same point disputing whether Billy was publicly exposed as cheating. BB then posited he shouldn't have to say much about Billy submitting scores, the second alternative imputation, as it's directly related to the first. BB addressed the third imputation, of Billy creating a video to fraudulently use as evidence. BB posited that imputation doesn't arise from an objective viewing of the video, pointing to more detail in his written submission. BB continued, more importantly, it's just not true. They can't establish the substantial truth of that imputation. BB added that KB's filing also lacks a detailed analysis to establish its truth. BB argued one need only listen to David Race's phone call recording, and the testimony Billy gave explaining his intentions, to know that Billy's plan doesn't rise to the level of fraud. BB then moved on to what he called, the pointed end of the spear being used against Mr. Mitchell, which would be the imputation that Billy callously expressed joy at news of Apollo Legend's death. BB accepted the imputation arises from the publication, citing testimony from Billy that Karl's video did carry that imputation. However, when tracking through KB's citations of testimony, BB disputed KB's characterization that Billy accepted that he actually did express joy at Apollo's death. BB posited, what Billy accepted is that the video said those words, not that he was actually expressing joy. BB then pointed Judge toward various text messages in the trial bundle, while reminding Judge of Billy's testimony that his remarks about Apollo were, according to him, facetious. BB then follows through Billy's text exchanges with Jace Hall, noting that in his reply to Billy Jace used the word clowntastic, with BB arguing that this emphasizes the facetiousness of the exchange. BB notes that Billy offered details about Apollo's appearance in Florida, with BB adding that Karl's video shows Apollo dressed up as Billy from that event. BB then reads the text "jackasses have coming," while apparently failing to specify this was Billy's remark, before referencing Jace's suggestion that Twin Galaxies publish an editorial on it. BB lightly referenced the totality of Billy's text conversations with Jace, noting Billy's testimony that the score dispute had gotten tense and that Billy saw this as a way of engaging with Jace. BB added that Billy was clear in his testimony in this case that he did not think Apollo was actually dead at the time. BB continued, it's certainly not an expression of joy, it doesn't rise to the level of joyfulness or celebrating of it. It's certainly not my client's finest hour, saying these things. But we certainly say it doesn't prove the truth of an imputation that he expressed joy at a legitimate thought of Mr. Smith's death. BB posited that it's a difficult road to establish truth on that point, because the defense would have to show Billy believed the rumor of Apollo's death was true, which BB argued the defense was not able to do. BB added that the judge would also have to find that these comments rise to the level of expressing joy about it, while reiterating his own position that they don't rise to the level of joy or celebration. During this sequence, you could see the slanted daylight coming in heavily through the windows behind the judge. The original 5 days of trial were all conducted in courtroom 38, which I believe faced to the east. However, these 2 online days were held in nearby courtroom 39, which from this limited vantage point appeared to suffer from the afternoon sun. I also realized around this time, these mofos didn't seem to care for breaks, with no rest taken in the 3 hours prior to lunch, and no apparent impetus to pause the action after. BB then argued the position is even more difficult when looking at Billy's exchange with Carlos. BB suggested that Carlos' own texts confirms the two were engaging in humor, or at least banter, adding this becomes clearer during the end of the exchange. BB reiterated his position that the defense has to show that Billy believed Apollo was dead in order to show that Billy expressed joy at the thought of it. BB noted their references in conversation to Reddit, while calling back to Billy's testimony of what he thought of Reddit. BB continued by pointing to Carlos in the texts identifying the reports as trolls, to which Billy agreed before they continued with, as BB put it, the banter. BB thus argued, if we get to the point that Your Honor accepts that they believe the Reddit posts were a troll post, then Your Honor accepts that Mr. Mitchell didn't believe at any time that Mr. Smith was dead here. BB put forward that this would be consistent with Billy's testimony about Reddit in general, and that if they didn't believe Apollo was dead then the exchange that followed would indeed be humor or banter. BB reiterated that it's not their finest hours, but that it would not rise to being proof that Billy expressed joy at the thought of Apollo's death. For what it's worth, BB seemed to be getting tired, and kept mixing up his references to Mr. Smith and Mr. Mitchell. At this point, Judge spoke up to note that Billy did originally say, no joke, Apollo legend is dead, my wife found online, and, if it is true I will not shed a tear, I will try my very hardest and not to smile or giggle. Judge noted those remarks were shortly after 11 p.m., and that it wasn't until after 11:30 p.m. that he was told it looked like a troll post. As an appreciator of language, I loved that, unlike the terms gamer and clowntastic, the judge and barristers each threw around the term troll post with no reservation. Therefore, as Judge put it, when Billy made the comment about not shedding a tear, it was at a stage where he didn't know whether it was a troll post. Judge continued that it couldn't also be said Billy believed it to be true, given the word if, before remarking, it's maybe that he didn't think Apollo was dead, but if he is dead, hip hip hooray. Judge concluded his impression that that would be the sting of the alleged imputation. BB noted that, with regard to the remark of, no joke, Billy was cross-examined about the meaning of it. BB cited Billy's testimony that, no joke, was not a reference to the claim Apollo was dead, but that his wife had found the claim online. Judge agreed that's how it reads, and BB remarked that's consistent with other testimony. However, Judge interjected that if that was correct, Billy's remark that he'd try not to smile or giggle would suggest not that Billy believed Apollo was dead, but that Billy was expressing joy at the thought he might have died. Judge then turned to the language of the fourth alternative imputation, noting that KB's written submission highlights this part as establishing that Billy had callously expressed joy at the thought of Mr. Smith's death. Judge mulled through the paperwork before observing that this imputation doesn't require Billy to believe Apollo was dead, just that he had a thought Apollo might be dead, and if so, expressed that he would be pleased. BB then focused on the language, the thought of Mr. Smith's death, reiterating his position that the evidence does not show that Billy at any time thought Apollo was dead. Judge countered that it's more about the thought of the proposition that Apollo may be dead. BB proposed, if Judge chooses to look at it that way, two responses would follow from that. First, BB rhetorically asked if Billy was simply being facetious and engaging in bad humor about it, which may be the case if it was merely a thought that Apollo could be dead, which BB argued would line up more with the banter part of the exchange. Secondly, BB argued, that would be very different in terms of the sting of the two competing imputations. Judge recalled KB's earlier submission to this point was made in the context of Billy believing that the report of Apollo's death was true, which KB used as the basis for arguing that this imputation is much worse than calling someone a pedophile. BB continued, if the court relies on that interpretation, then that sting does not do greater harm than the main alleged imputation Billy's case is arguing. BB then argued that, if the court agrees that the given imputation has no greater sting than the main alleged imputation, then given the way the defense presented their case, none of the others would as well. BB then rounded out the segment by addressing the fifth alternative imputation, that Billy uses litigation to force third parties to recognize his achievements, reiterating that his other points would apply here as well. BB continued pointing out what appeared to be a copy and paste of two passages in KB's filings, to which the judge remarked he meant to ask about that, with BB arguing the passage doesn't apply toward the fifth imputation as it was pasted. Of course, I don't have the passage to show you all. The home stretch. At long last, BB addressed the question of damages. BB began by calling back to KB's citation of the Harrington case, claiming that a number of details from that case paint a stark contrast to this one. First, reading from that case's synopsis, no evidence was presented in that case that Mr. Harrington suffered any distress, which BB claimed was very different from this matter. Second, according to BB, the Harrington evidence showed the defamatory statements had no effect on Harrington's wife, or that anyone else in their community were aware of the statements, saying the damage was limited to two people who read a sign. Thus, BB argued, there was no need to award damages to vindicate Harrington in the eyes of the community, which BB posited would also be a distinguishing factor here. BB characterized the harm done in Harrington as modest, and the injury as short-lived, arguing that also distinguishes that case in the context of aggravated damages. Judge agreed that did offer some distinction, however he also noted the previous judge relied on many other cases which had broader publication and clear evidence of adverse effects, where aggravated damages were still limited to the $100,000 range, whereas Billy is seeking $450,000. BB noted he didn't have those decisions on hand to discuss those details, but Judge remarked the Harrington judge's summaries would probably suffice here. BB noted that one of those cases, Bert Whistle, relied on statements made to a member of the plaintiff's family, which would have been a limited publication. BB added that Grattan also seemed to be a narrower publication than in this matter, while Athelwood was a bit broader. BB may have been reading from this very summary of Harrington here. BB remarked that, between those three rulings, as the publication broadened the damages increased significantly, arguing that in this case the extent of the publication is broader still. BB also noted, in his estimation, that those related to reputation, where in this case reputation is coupled with the harm to the plaintiff and his, and I quote, hurt feelings. BB called back to very compelling evidence from Billy about how Karl's video affected him, to the extent that Billy was vomiting, not sleeping, and was worried he would lose his marriage. Note that, as I finish this write-up, I'm not sure if that last point was adequately reflected in my on-location write-ups. BB also proposed a general damages award as a means of vindication, adding that the question of malice could further distinguish this case from the others. BB posited that, of the cited cases, Athelwood, with its $100,000 award would be the closest, and that it's still significantly different than the circumstances here. Judge asked BB to recall what the relevant cap would be on damages for non-economic loss. BB believed it to be $478,500 for non-economic and non-aggravated damages. Judge then asked if the legal limit is imposed based on the law as of the date of trial or the day proceedings were commenced. BB admitted he was unsure, and Judge conceded it was not clear to him either. BB proposed it could be based on the date of judgment, suggesting the harm could continue, and that the conduct up to and including the matter could be relevant. I can't say for sure what was meant by the matter, but it sounded like that could refer to the trial and related publicity itself. BB thus suggested his impression that it would be a later time, but admitted he couldn't cite authority to that point. Judge asked, with a laugh, if that meant that if he was slow to render a judgment, and if the legal limit was increased in the meantime, if that would increase the amount of damages he could award. Judge concluded this was an open question to be addressed as needed. Judge continued to say, the more important concern for this case is that the authorities say that given maximum is for the absolute worst cases, asking BB how this case could be anywhere near the worst of cases. BB declined to assert that this was among the worst of cases, but countered that, it's certainly very serious. Judge remarked, but if the maximum is $478,500 for the worst of cases, this wouldn't even approach $400,000, would it? BB reiterated once again, it's certainly very serious, adding that the figure would also include aggravated damages as well. BB argued that a publication suggesting that one, through their conduct, was a contributing factor to someone taking their own life is a very serious matter, adding, it's not calling him a murderer or anything like that, but it is very serious. BB argued that it would then be coupled with the extent of the publication, and the very large numbers of people who saw it. BB reiterated, we're talking about a situation that had a very serious impact to the plaintiff personally, the hurt feelings, and the physical impact it had on him. BB argued that the impact of the video was on the worse end of things, describing again Billy's testimony about his physical reaction, his vomiting, and his lack of sleep, his loss of weight, and his seeking out of counseling, calling these serious matters. BB added there was no contest from the other side that these wouldn't be genuine responses to a publication of this nature. Judge replied that there was some contest, that it was effectively alleged that Billy didn't have these responses he described, given that Billy made identical statements during the twin Galaxies deposition. BB moves on by suggesting that, if the court accepts Billy's testimony, then the harm described would be to a serious extent. BB continued to say, in terms of reputation, the court has seen the serious impact the video has had. BB did wish to be clear again that his side is not suing for economic loss, but that the alleged drop in appearances demonstrates the effect of Billy's reputation being damaged, and the impact on Billy himself. BB referred back again to Billy's testimony to the effect he could lose his wife, calling that the fear Billy spoke of. BB then referred again to the possibility of an award to vindicate Billy, saying it ties into the issue of malice. BB suggested to the judge, "You've heard what Mr. Jobst has said, and you've seen what Mr. Jobst has done since then in terms of the number of videos he's posted about Mr. Mitchell, and you've seen Mr. Jobst's attitude toward this litigation by way of his tweets." BB argued that, while it may not be the worst kind of imputation that one could have made against someone, all of the circumstances require a serious amount in the judgment. BB then called back to the other case law comparisons, adding that the judgment in Ciarocci was around $200,000, while arguing that this case is worse. BB then lodged an objection to certain passages from KB's written submission, arguing that the case cited was not pleaded. That case, as BB elaborated, was the Twin Galaxies proceeding in California. BB argued that, looking at the standalone facts alleged, they aren't facts that this court ought to find have an impact on damages claimed from Karl's video. BB continued that KB's written submission is attempting to argue that the damages were caused by the Twin Galaxies dispute, adding that this argument also was not pleaded. Note that, if this suggestion from BB is true, per my understanding, this would not discount the use of Billy's deposition in assailing Billy's credibility. It would just mean that Karl's side may not be able to formally argue that Billy's ill effects are the result of the prior TG statements and not Karl's video. BB then pointed to another passage which referenced the Cartoon Network proceedings, which BB claimed were nowhere in the pleadings. Judge then asked if this related to an interlocutory, provisional, application heard by a previous judge, to which BB reminded the judge about KB's motion to amend their pleadings during the trial on day 3. BB recalled this was an attempt by KB to contend that one cause for Billy's ill effects was the Twin Galaxies proceeding, noting that this argument was not properly included in their trial pleading. BB continued to say, a lot of these passages go to that point, but are framed as if they're speaking to reputation, suggesting that KB is attempting to bring this denied line of argument in through the back door. By this point, the sun bleeding into the room had passed, with the room appearing a little darker than before. For me, it was a half hour until midnight, but locally it was 4:30 p.m., which did feel a bit early for a sunset, given it was springtime in Australia. BB took a moment to flip through his voluminous paperwork, before challenging an aforementioned passage from KB's written submission, which claimed Billy accepted he had a settled reputation for cheating. BB suggested the evidence doesn't go that far, noting that Billy accepted the video said those things but did not accept he had that reputation. BB added that many of KB's submission points are the same points relating to reputation, repeated in other contexts. BB brought up the Grapevine effect, pointing to a portion of KB's submissions. BB referred to the inclusion of the full suite of replies to Charlie's videos, and to arguments from KB that the overwhelming majority of relevant comments refer to variations of cheating. BB countered by claiming to have done an analysis, which found only 86 comments on the "He's a Cheater" video referencing both Cheat and Billy Mitchell in the same reply, which would total 1.4% of the total 5,840 comments. I don't think I need to explain to you the flaws in this methodology. BB then cited 82 such references among the 4,483 replies to "He's So Desperate Now," totaling 1.8% of those replies. BB summarized, "We would submit that on no basis is that an overwhelming majority." Upon a judge clarification, BB suggested there may be a handful more that refer to just "cheat" without a direct reference to Billy by name. BB summarized, "Our submission is essentially that 2.5 to 3 years later, in a different video by a different author about Mr. Mitchell, these same comments are coming up." BB called this extraordinary, suggesting normally cases like this have to deal with inference and understanding, adding that this case gets actual evidence, to which judge acknowledged BB was referring to the comments he tendered. BB added that Junior testified to other people reposting Karl's original video, and that he may have seen it earlier that same day. BB clarified this was, not from Mr. Jobst, I wish to be very clear about that, but from someone else who had taken it somehow with technology and put it up. BB recalled testimony from Charlie, to the effect that Charlie streamed the video with commentary, which someone else then copied and reposted. BB added that Mr. Mitchell is still seeing versions of it from others as well, before stressing that the Grapevine effect is real and significant here. BB asserted that, in KB's submission, nothing was said about the impact on plaintiff's hurt feelings. Always Billy with the hurt feelings. BB continued to attest that KB's submission said nothing about damages to vindicate Billy's reputation, and offered nothing really to counter BB's written submissions toward malice. BB said his only remaining disputes with KB's submission related to Karl's retraction video, but suggested his written submission made their points to that, noting that judge already addressed many of these points in his questions to KB. KB then noted the hour, and suggested they could move on to judge's questions, remarking that he's pretty much delved into their case already. Judge added he probably already asked all the questions he intended to, before going over a technical citation correction in BB's submission, and asking for a refresher on the nature of Billy's cameo referred to in Charlie's testimony. Judge pointed to one passage from BB, which read to the effect that Twin Galaxies' dispute statement did not explicitly accuse Billy of submitting scores to trick TG into recognizing them. Judge then asked, isn't the statement, as a whole, to the effect that he achieved 2 of the scores by breaking the rules, by using MAME or not using an unmodified Donkey Kong PCB? Judge then asked, would that not be the same as trying to trick or deceive TG into recognizing those scores? BB suggested there's a fine distinction between the TG allegation and cheating with an intent to deceive, characterizing TG's conclusion as finding that Billy played on a different PCB. BB continued that this could have happened without Billy's knowledge or intent, offering that as a subtle distinction. As BB put it, the TG statement did not assert that Billy knew it was an illegitimate PCB, adding that TG seemed to be very careful in their statement to say they found it was achieved on certain equipment without elaborating further. After a lengthy silence, Judge spoke up again, referring to another passage asserting Billy did not hound Apollo to death, and that Billy's conduct did not cause or contribute to Apollo taking his own life. Judge noted this was listed under deemed admissions, while pointing out BB also acknowledges the defense hasn't admitted the latter of those. In response, BB walked through various items in the written statement of claim, while apologizing if it was made confusing. Judge reiterated that the noted claim was listed under deemed admissions, adding that will depend on what is said about those alleged imputations. BB clarified that he's asserting the imputation is false, whereas Judge gathered the defense is refusing to acknowledge the imputation arose at all, adding that if those imputations do arise, the defense is not denying they're false. Both BB and Judge then agree that the defense has deemed to admit or deemed to have admitted they were false, whatever that term means exactly. Judge then declared those were the end of his questions for BB, remarking that the injury time was about the same. I was very confused by this remark, until I realized it's probably a metaphorical reference to extra time in non-American sports like soccer. Judge asked KB for any reply, to which KB offered his intention to be brief. KB referred to discussions around reputation and the decision in Peros. As KB argued, one of the submissions that was made was that Mr. McNutt's testimony was unhelpful because he had never seen the video. KB suggested this reflects a misunderstanding of the law from Peros, arguing that whether or not a witness has seen a publication has no influence at all on what they say a given person's reputation was at a particular moment in time. KB recalled asking each of the witnesses about particular points in time, and asking each of them basically the same set of questions about their understanding of Billy's reputation at those points in time. KB suggested the whole point of that process was to satisfy the test in Peros, which was to establish a settled reputation at different points in time, including their understanding of Billy's reputation after Karl's video. KB asked Judge to recall that all of the defense witnesses said that, between the point in time immediately before Karl's video to immediately afterward, Billy's settled reputation had not changed. According to KB, the whole point of that exercise was to satisfy this question of settled reputation at various points in time. KB continued to say, whether Mr. McNutt saw the publication at any time matters nil, because all that could do is affect his own view of Billy, not what his understanding of Billy's reputation was at that moment in time. KB referred to the decisions in Favel and Bros, asking the judge to look at Bros, section 3.2.2. I believe this to be available as page 26 here. KB suggested Bros goes through all of the considerations on what the imputations are. KB noted there seemed to be misunderstanding that the defense argument was that the judge should just look at the strict structure of the words being used in Karl's video, clarifying that was not the point of his submission, saying that it was just one consideration. As KB then remarked, it was asserted that even if Billy did have a particular reputation, it was corrected in 2020 by the Guinness reinstatement. KB pointed out this argument was not pleaded, citing the relevant pleading as saying something else. KB, hand back in his pouch/pocket, noted there were submissions made relating to the topic of sectoring, and the decision in O'Hagan. KB recalled that case involved a police officer accused of paying to have someone killed. KB suggested, if we draw an analogy to the current situation using the facts from O'Hagan, it would be a hypothetical where an officer paid to kill someone who intended to complain to the CCC. KB continued, the reason he added that additional part is because that's what drives it back to the profession. Judge remarked he doesn't understand the analogy between that and this case. KB offered that, per his earlier submissions, the imputations in this case all relate to Billy protecting his video gaming scores. Thus, the analogy would be if O'Hagan did what he did to protect his job. The final point KB wished to make was that, right at the beginning of my learned friend submissions, arguments were given relating to Billy's deposition testimony. KB could not recall the exact words, but the effect was that BB was attempting to explain what Billy meant when he gave that deposition testimony. KB pointed out that Judge put forth that Billy was not cross-examined on that point. KB astutely pointed out that Billy's explanation for his deposition discrepancy was given during re-examination, and that KB didn't challenge it because of that. In other words, Billy's story where he attempted to patch up the obvious lie he was caught in was introduced after KB's only opportunity to question Billy had ended. Judge thanked both barristers and their instructors for their handling of this very difficult case. Judge continued, "I will reserve my decision. I can't at present give any indication of when I'll be able to hand down my decision." Judge noted he has a number other outstanding judgments that take priority, before adding, "I will do so as soon as I can." Judge then confirmed he has all exhibits from both parties, before promptly adjourning the trial for the last time. And on the 7th day, he rested. We're almost there, folks. But unfortunately for you jokers, I do have a few closing remarks of my own I feel compelled to add to this discussion. I'd like to frame those by way of addressing a very important question. Is it possible Karl Jobst could lose this case? Let's get 3 important truths out of the way. First, Billy Mitchell should not win this case. Not if justice is served. He wasn't meaningfully defamed. Karl didn't say what Billy claimed he said. The offending statement did not affect Billy's reputation. I don't believe for a second that this lawsuit is about anything other than chasing money and seeking revenge, and I also don't believe Billy's bullshit about being personally affected by anything other than his childish ego. Billy's YouTube response was also less about informing the public, given his wild mischaracterizations, as it was a transparent attempt to inflame any alleged defamation and reputational harm in order to prime his impending lawsuit. As I've illustrated previously, Billy Mitchell purposefully seeks to restrict information, fills that vacuum with lies, and then in this case has the audacity to seek legal action against those who report on either his or his son's lies as fact. This is just another in a long line of predatory litigations from a narcissist seeking to weaponize the public courts against his critics. Second, as I'm sure you all are aware, the right side doesn't always win these legal cases. Granted, this one will be decided by an astute and educated judge involved, and not a jury of randos who may think the Earth is flat or that Voyager was better than Deep Space Nine. But that doesn't necessarily guarantee victory, either. To this point, while some of BB's arguments may sound preposterous to you and I, especially when we know the circumstances behind the case which Billy is misrepresenting, it could be that within these lawyer circles BB's arguments are the most legally sound, and that it's actually KB who's grasping at judicial straws. And there's a third thing those of us on the side of truth must reckon with as well. Karl Jobst should not have made the claim about the Apollo settlement in the way that he did. I say that with some big caveats, of course. When I personally first heard Karl's words, I believed Karl to be in the clear, given his phrasing did not specifically attribute Apollo's decision to Billy, but rather simply described a sequence of events, each of which were believed to be factual. And as I've discussed in Day 0 and Day 5, we really did believe the claim of a financial payout to be true at the time. But we did not have conclusive proof, and so it was a mistake for Karl to report the claim as settled fact. Granted, if Karl had qualified the claim with terms like almost surely or reasonably certain, as I was doing at the time, there would have been nothing to stop Billy from suing anyway, claiming that the imputation arises regardless. Again, as demonstrated by Billy's long litany of threats to Karl and others, this was more about Billy seeking revenge than it was about the specifics of the claim. With that said, we did have reasonable basis for believing the claim was true. And this basis was hardly fazed by Billy's YouTube posturing, where he waved a piece of paper around and angrily asserted it would prove everything he was saying while refusing to show it to you. And, as we saw during the course of the trial, with the revelation of a lasting non-disparagement clause binding Apollo with predefined penalties, Billy still couldn't help but sprinkle lies into that video as well. The agreement had no long-lasting impact on Apollo's life, and did not exert any impact afterwards. Somehow, Billy waving around a stack of papers claiming it's his secret proof just doesn't have a lot of impact with some of us. And this is where we get to the first of a few key screw-ups by Karl's legal team from Mills Oakley. First, the lawyers should have included in their pleadings the evidence we had indicating a financial payment from Apollo to Billy, and should have arrived to trial with the intention of proving that line of defense. Granted, I'm not going to stand here and tell you I'm an expert on Australian defamation law, or whether I had evidence is a quality defense against a defamation claim there. But I do know this was a mistake by Karl's attorneys, because on Day 4, KB himself attempted to argue this line of evidence, and was promptly and astutely shot down by the judge pursuant to an objection by BB. As I wrote in that day's summary. Basically, if the defense failed to argue in its pleadings that Karl took sufficient steps to confirm this information prior to publication, then the prosecution's allegation that Karl did not do so stands effectively undenied. The defense, therefore, cannot start entering evidence and arguments supporting a contention they never made in the pleadings. The reason this was more than a mere technicality is because those pleadings are what inform the opposition of what evidence and testimony they need to be prepared for, ensuring a fair and thorough trial. I still recall the awkward silence, where KB stood there speechless, unsure of how to proceed. And even aside from strict legal matters, if Judge were to see this effective admission not as a technical snafu but as a literal admission by Karl that he had no basis for the claim, this plays right into Billy's attempts to paint Karl as an unreasonable agent looking to provoke Billy into a fight. Karl's lawyers hamstrung him from the get-go by failing to engage this line of defense properly. Late in Day 7 above, we got a glimpse of another failure by Karl's lawyers to properly plead their case. If I'm to believe BB's presentation, which it doesn't seem KB contested, the Mills Oakley crew also didn't include the argument that any deleterious symptoms of Billy's were the result of lasting effects from the twin Galaxies litigation. I mean, did they not research this guy at all? Did they not know he would just come to court and tell a bunch of lies that would have to be challenged? I would say KB's Day 7 gaffe was the biggest in-trial blunder by either barrister, just because of how basic the timeline of events is to his client's case, but I believe the effects of that snafu will be minimal. The same obviously can't be said about these pleading errors, which ultimately handicapped their own ability to argue their case as the events of the trial unfolded. However, there was an even worse omission from their pleadings, which could ultimately hurt Karl's chances even more, and it relates to something I don't believe I've discussed yet this entire series. People were already blaming Billy Mitchell for Apollo's death months before Karl's video. The above tweet, posted 3 days after Apollo's suicide, references this phenomenon in real time. After this situation became a full-blown legal battle, I went back and collected numerous examples of people on social media outright blaming Billy for Apollo's suicide during the timeframe prior to Karl's video. I'm not going to highlight those more direct examples here, which could unfairly put those individuals on blast, but suffice to say, they're not that hard to find. Granted, the way courts work, you can't just show stuff and let it speak for itself, and obviously Karl wasn't going to call these individual tweet authors to testify to this point. But as we saw, there are other ways to get key material like this entered into evidence. I would have happily testified to having researched the matter and would have supplied that research, even if it meant foregoing my opportunity to report on the trial as a non-party. Let's make no mistake on this one, this failure by Karl's legal team allowed Billy's side to run with the false, unchallenged narrative that any and all instances of people blaming Billy for Apollo's suicide after May 26, 2021 are solely attributable to this one video from Karl Jobst. And that simply is not true. In the real world, those of us following the case know this proposition was preposterous. But in the limited sphere of the court, an unchallenged narrative remains unchallenged. Based on these failures, I have to conclude that Karl's legal team was too cocky, and thought they could show up to court with 1 or 2 defenses, before haphazardly realizing at trial they needed to attempt to sneak in a few more. I would say perhaps Karl was overconfident as well, but it's his lawyers who are supposed to know how to evaluate this evidence and assess their needs. If Karl Jobst does lose this case, these mistakes will be why. With that said, I'm not looking to be a doomer here. If I were in Billy's camp, I would still be worried shitless. Billy's conflicting testimony between his deposition and this Australia case is exceptionally damning, and should cause the judge to scuttle everything he claims. And without Billy's testimony, his case basically evaporates. And that's before you get to Billy's other blatant attempts to bullshit the process, including his indignant reaction to being caught in a lie regarding the Music City multi-con. Even those emails from John Weeks and Ryan Berger would get banished, since they relied on Billy's authentication and not on direct testimony from either Weeks or Berger. BB's attempts to question Jr. about the Weeks cancellation drew a hearsay objection. And of course you had the parade of witnesses on both sides who basically said, yeah, Billy's reputation remained unchanged. Then you have Elliot Watkins' superb testimony. To the effect that, sure, Karl's video showed a repulsive side to Billy's nature, but it was Billy's texts joking about Apollo's reported death which made the impression. How exactly could one expect Judge to determine that any damages were due to one specific, untrue claim, when it cannot be separated from a video filled with so much other truthful reporting of Billy's repugnant behavior? Some judges consider themselves to be merely cogs in the wheel, allowed only to observe strict matters of written law. In a world of appeals and precedent and judicial oversight, this perspective can be understandable. It tends to be the personally safer and more conservative approach. But that methodology also allows malignant actors like Billy Mitchell free rein to manipulate the process. Billy knows he can lie under oath, and that at least some of those lies will go unchallenged. True justice requires judges, and juries, to see the totality of what's going on before them. It obliges finders of fact to differentiate bad faith actors from honest individuals who make mistakes, and to recognize patterns of dishonesty and act accordingly. Judge Ken Barlow strikes me as an astute adjudicator, often asking exactly the sorts of clarifying questions I was hoping he would. I just hope, now that the case is out of the attorney's control, that he sees the totality of what's going on here. Thank you as always for reading. And I want to give a tremendous thank you to everyone who has donated to my GoFundMe, helping to recover the costs associated with my trip to Brisbane to cover this trial in person. As I finish this, the total raised is exactly $2,000. Given the length of this update, I'm trying to be concise here, but I really cannot thank you all enough. If you appreciate this coverage, and haven't yet donated, please consider doing so here. https://www.gofundme.com/f/support-the-Australia-trial-coverage-by-airs@scats. Also, super quickly, our recent promotion with Thiefsplay just got extended through November 11th. If you love classic Street Fighter 2, and want to win sweet shoes for free, consider dropping a high score here. https://www.twinGalaxiescom/game/bounty challenge/bounty challenges/the Loggear Retro Fighting Game Challenge brought to you by PerfectPacman.com. I'll be applying the same stricter comment moderation standard as with Day 6 here. Don't worry, other posts are still available for a looser comment atmosphere. Let's all hope justice wins out.
New videos every Monday and Sunday. Thank you for joining me on another episode of the Gen X Gamer. Remember to like and subscribe, click that notification bell, and remember, never ever be afraid to be happy. I'll catch you on the next one. Take care.